All caps means you're either panicking or trying to represent yourself in court. Both are mistakes. Your feelings are adorable, but they're not admissible, persuasive, or even interesting without evidence. Yes, Heather hates immunity doctrines. It's a personality trait at this point. You don't need to remind her, she wakes up angry about it. Bring receipts. No, I heard it from so and so. This is quid pro quo, not next door. Screenshots are statutes only. Don't fight each other. Fight the law. It deserves it more. If you're offended, excellent. That means you're awake, paying attention, and probably new here. No diagnosing the host. She's petty, not pathological. And don't diagnose anyone else. Stay in your lane, please and thank you. Do not summon the mods. They're tired, hangry, and may bite when provoked. Disagree loudly if you must. The algorithm eats drama for breakfast. Just keep it cute while you argue wrongfully. If you're taking screenshots of my chat, touch grass, tell your handlers. I said hi and find a hobby that isn't me.
Hey everybody, I have absolutely no idea what the heck just happened. Were you guys live with me when I said I was potty training and I had to go change or get the little on, her potty chair? Well, we didn't make it. I came back. Everything looked good from the StreamYard side of things, but the YouTube Studio side of things said upcoming stream still. It didn't say live. I went into Studio and it's like, stream hasn't started yet. And I'm like, wait, I get the little live stream, or the live symbol and how long I've been live and how many people are in chat or how many people are watching in the corner. And it said a number, the same number that it said when I left to go change the little. And it kept ticking. And apparently something happened with Anyway, that was so weird. It started, and as far as YouTube was concerned, or StreamYard was concerned, I was live for 17 minutes. And as far as YouTube Studio, it said stream hasn't started. So there was something going on where StreamYard and YouTube were not getting along today. So if anything happens, can someone message me on either Discord or text me or something to well, StreamYard wasn't the problem. StreamYard was like, everything was good. It was YouTube Studio that was like not cooperating. I don't know. Blame Jeremy. Oh yeah, speaking of YouTube, I swear it's just effing with everyone. Speaking of everyone, go check out Good Logic on Twitter. Ian Runkle on Twitter, Andrea Burkhart's been tweeting about it a lot. Those are the only three that I follow that I saw. Apparently YouTube told Ian Runkle, the nicest guy on freaking YouTube, like Canadian firearms lawyer, the nicest guy on freaking YouTube, the nicest, most respectful person in LawTube, that he broke terms of service or something and gave his channel a strike. And didn't tell him why. So if you can go on Twitter, look up either Ian Runkle of the Bailey, Good Logic, or Andrea Burkhart. Those are the three that I saw tweeting about it, and retweet Team YouTube to fix their shit. Am I prepared for this winter storm? Yes, because the only person in this household right now that's affected by it is my father when he has to go back to his house. It is 60 degrees and sunny here right now, I don't really know if we're supposed to get any sort of like rain or anything. So, you know, I'm not really sure. So I'm prepared. But I'm also like, take where the about where the expert says he is, and I'm about 5 to 6 hours south of that. So like I'm, you know, I'm closer to Florida than Tennessee, let's put it that way. So, huh, with that being said, I do have us set up to, and this is part of probably where it gets a little funky, is this is going to be a quicker stream because of the fact that these documents are short, straight to the point, procedural, not a lot to them. And I have some things to say about them, but not a lot. So I have us redirecting when we are done here over to my other stream that is Tyler Robinson case updates and new motions. Yesterday, we went through the Tyler Robinson hearing from last Friday, and we are going to discuss the motions that were filed in that case, including the motion for a speedy trial filed by Charlie Kirk's wife, Erica, and the reason she can do that in Utah. With that being said, we we are going to get straight into this, because I had this whole like monologue that I wrote, like discussing what to do. So FYI, when we talk about people and you hear me go off on people, or we attack people's actions, not who they are as people. The only people who I will personally attack and like go after every aspect of their life are people who either go after my daughter, i.e. Bruce Matskin and Felisa the dog, or Thunder Cunt as she's known on this channel, and or if you accuse me of a felony for reading documents. Speaking of which, if you have not joined us for our Loose Lips Sink Ships playlist and series, I am reading every document that a certain Flipsy Lipsy has ever put her signature on in the court system. Right now, we are going through her lawsuit against the Florida bar that is filed on Pacer. Because when you accuse me of a felony, I am not petty enough to sue you because you have 2 houses in foreclosure. You can't give me anything I want. However, I can embarrass the shit out of you and make content out of you and monetize you until at least 2027 with as many stupid lawsuits as you filed. So not only will I be keeping up with her foreclosures and the lawsuit that Jeremy and Megan and Tug have against her, however, I will be reading every fucking document that's ever been filed in a case that she has been the plaintiff and or defendant in. Actions have consequences, and I'm petty, but I can't sue you because you have nothing. So it'll just be a waste of fucking time, energy, and money. But you do have something that I want. It's called, well, I have something that you don't have. It's called integrity. But that being said, I can sure get some serious fucking entertainment out of this. And I will till the end of fucking time. Or at least 2027, whichever happens first. And the way this fucking this world is going, who the hell knows if we're even going to be here in 2027? Yeah. I have started with her lawsuits on Pacer because when you fuck with somebody, make sure they don't have a fucking Pacer account and can get a hold. Oh, and because her husband sat there and co-signed all of her bullshit statements about people reading documents, practicing law without a license, blah, blah, blah. We're going to do him next. Yeah. Oh, yes, Chad, if you missed Squid going off regarding the VA disability, highly recommend you watch. Yeah. I did not. They have been sealed. And hey, Terry, I haven't seen you in a while. It's been a minute. How are you doing? But we are going to get into these documents today. They are short, straight to the point. However, I know I have been sent the fact that Jeremy posted a video and saying that he won. In a way, he did. However, we still have some stuff to talk about before that because it's not completely over. It may be, but it's not completely over. Yeah. So this is a status report. Every 90 days, Jeremy has to file a status report in Federal 2 due to LMNOP's bankruptcy. I actually read this in the other stream that didn't apparently exist. It's procedural. There's nothing in here about Fleesa and her interjecting herself. July 3rd, LMNOP filed the bankruptcy. July 15th, court entered an order staying as to defendant Preston, requesting plaintiff file a status report every 90 days. Here we go. October 21st, bankruptcy court granted debtor's motion to reinstate case. January 12th, meeting of creditors was held but not concluded. Hearing on objection to debtor's claim of exemptions is scheduled on February 10th at 10:30 Eastern via Tallahassee courtroom. Proof of claims are due by 4/2/2026. This will be interesting as far as Fleesa claiming she's a creditor, because now you need proof that you're a creditor. Plaintiffs will continue to monitor bankruptcy and update this court, blah, blah, blah. That was filed last week. I'm only talking about it because, one, it gives us a reminder on the dates and the timeline, which everybody I feel like needs every once in a while because there's so many dates and numbers and cases flying around in this whole situation that every once in a while we need a refresher on the timeline. And that way no one can say, hey, did you hear about this? Hey, did you hear about this? So, you know. Oh, moral of the story, don't hide from service and answer court requests. Well, here's the thing. In my nice petty monologue that I had going, which I wrote it, I put it in a chat GPT and I said, please make extra spicy because I'm feeling kind of spicy today. And it did. And here's the thing. Here's the thing that I can take out of it and share it with you without going into the whole 2-3 minutes again. The court kept this drama-free and procedural. You were served in multitude of different ways, but it's no longer about you claiming that you didn't know or that service wasn't right. When you get on YouTube and you talk about how you're actively avoiding service, the court doesn't care about YouTube drama. The court cares about procedures. And the court basically said, you didn't answer, you were served, you had alternate service, you were provided with alternate service, you still didn't answer. You're done. So this was the first document. There's 5 of them real quick. Tell Squid to put up the flower. It's right here. I just was on my welcome. I have a solo scene. I have different scenes like this one, Mama Duties. But I had it here and I didn't have the so update layout. Okay, hold on. I have to go put the little on the potty chair because that's where we're at right now. I will be back in a heartbeat. Hopefully this time when I come back, like, things will be normal. Like, hopefully. We have apparently hit our limit for attempting to sit on the chair with mommy today. She will do it probably again when daddy gets home because she is a daddy's girl and she does things for him that she will not do for me. However, she was officially over it and I just changed her diaper. So, oh no. Oh no. I hope he feels better. Sick little ones are always awful. The little woke up congested this morning and I got a little nervous. Yes, and please hit that thumbs up. I would really appreciate it. And if you hate me and hate my guts, but you're here lurking anyway because you want to watch everything I do to see if there's something that I say that you can use against me, please hit that thumbs down. It all helps me with the algorithm. I appreciate it. And if you have not subscribed to my other channel, please do that. That is my heart and soul, my baby. And I promise, once my schedule gets back to normal, aka my father is down here visiting and we're going to builders meetings and stuff, I will be uploading content to that channel again. But we do have a live stream every Sunday. So, and hey, Lynn. Oh, Tree God is here? Where's Tree God? Where's he at? Where is she? Where? All right. Don't kill the messenger, but a clerk entry of default. Yes. And this was, and thank you, Jeff, because that is what I will get to, because Jeff and I were talking earlier, and I'm glad he brought it up because that's what I was thinking too. And I know that sometimes you need clicks and you need views on YouTube, and sometimes you get a little clickbaity, but remember when default judgments were put in against Lynette and John back in this case, back last year, early last year, document like 10, 15, they filed a motion, a Rule 55C, 55E of the Rules of Federal Procedure. And they when they made that, they made a rule, or they said, hey, by the way, we didn't know, or we didn't file in time, and the judge set aside the default judgment. It is possible. So just because there is a default judgment entered does not 100% mean it's over. However, due to the fact that Luthman is just Luthman, and he tends to not, I don't know, he strikes me as he strikes me as lazy. And like, if he's not going, if he doesn't have to, he's not going to. He filed the stuff, or his father filed the stuff to create drama, but filing a motion to set aside a default judgment means that you're actually going to have to like step up and do shit. And I don't see him as being that energetic to do it. Maybe it's just me. Yes, but don't kill the messenger. I just go by procedural and the rules here. We don't go by what I want to happen. We just go by what can happen. Because even though the facts lead me to one side, I just, I don't 100% like either side, because no offense, but neither side has been particularly great to me. From a personal standpoint, not a YouTuber standpoint, from a personal standpoint. Me as a person, me as Heather, not me as Squid. And there's just some things that I'm like, neither side has been particularly nice to me. So I'm like, it's another reason why I don't pick sides, because you're not going to get along and you're not going to agree with everybody all the time. So still, he hasn't been served. Yes, he has. Well, technically he has, but we're going to get into that. All right. Motion for clerk's entry of default against defendant Richard Luthman. This was filed yesterday. May 1st, plaintiff filed their second amended complaint for damages against Luthman. After multiple diligent attempts for personally served, Luthman were unsuccessful due to his deliberate evasion of service. Plaintiff sought effective substitute service, and that's important. That right there is important, pursuant to Florida law. On November 5th, 2025, this court issued a pluri summons to serve defendant Luthman pursuant to Florida Statute 48-161 and 181. December 15th, substitute service of process was effected upon Luthman by serving the Florida Department of State, Division of Corporations, and the defendant's agent for service of process. The Florida Department of State, Division of Corporations, and Service of Process on December 29th, as evidenced by the letter from the Division of Corporations filed with this court, which we read, I believe, a long time ago. Pursuant to FRCP 4E, service upon an individual may be effected by following state law for serving a summons in an action brought in courts of general jurisdiction in the state where the district court is located or where service is made. The time for defendant Luthman to file a responsive pleading has expired because FRCP 12A1AI requires a defendant to serve an answer within 21 days after being served with the summons and complaint. More than 21 days have elapsed since December 29th, and defendant Luthman has failed to plead or otherwise defend as provided by the Federal Rules of Civil Procedure. FRCP 55A provides that when a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend, and that failure is shown by affidavit or otherwise, the clerk must enter the party's default. Defendant Luthman's not a minor, incompetent legally incompetent, no, mentally, yeah, but personality-wise, maybe. Or a member of the military. Oh God, could you imagine him being a member of the military? Jesus, Pete, man. I couldn't even imagine his response to getting yelled at by drill instructors. Could you even imagine? It's tomorrow. I'm remembering Friday the 23rd for some reason. And Ninja Puppy, thanks for being a member for 7 months. Subscribers only mode. Also, the other stream, I did see Rick Reed, I think. Thanks for being a member for 6 months. And somebody bought memberships. I think it was Hung Hero. I think. But with not being able to apparently go live, even though I was talking for like almost 20 minutes. Don't know. Might have to have Luthman formally analyzed and diagnosed. Yes. Formally analyzed. Personality-wise, or his actions of talking about an active case while claiming not to be served. That just doesn't scream competent to me. But not like a incapacitated, like not competent to stand trial kind of situation. It's more like you just dumb. You just dumb. Like, hey Shirley, it's okay. We had an interesting experience. Apparently I went live for 20 minutes or 17 and a half minutes, but YouTube didn't actually recognize that I was live, even though StreamYard did. Don't know what happened. Oh, and after we get done with this, we have to have a chat. Don't worry, not a bad chat. We just have to have a chat. I uploaded a short today that I think everybody needs to watch. Wherefore plaintiffs respectfully request the clerk to enter a default. So there's that. And we're going through these by number, so we're not skipping around. The default judgment was what the default judgment is like 154 or 155, but we are going to go to this one first. However, hey Nana Cat, you didn't do anything wrong. I don't know. I don't keep up with a lot of drama. However, when people like tell me off-putting things or things that have happened and kind of give me like a TLDR, they haven't mentioned his name lately. No one sent me like DMs or screenshots of, did you see what this person did? So I don't know. All right, this is a declaration of mailing. I, Randy Shockett, obviously not me, being duly sworn upon oath, depose and state as follows. I'm over the age of 18. Yep. I'm an attorney licensed to practice law. There's his barn number. And counsel for record, I have personal knowledge of the facts in this declaration and am competent to testify in these matters. What's up, Angel? Oh. Just in case you didn't know, this currently is our favorite, it's called Fruit Fetish. It's lip balm. But it is the little new favorite thing to go find in mommy's makeup drawer. Makeup. Try. You no, you're not trying because you get it everywhere. Here. You try, but only on your lips. It's not eyeshadow. There you go. This and this. This is the other favorite. I love this stuff, dude. I love this stuff. Like an overnight. Love it. October 22nd, I caused to be sent via U.S. Postal Service priority mail authenticated copies of summons and complaint in the above captioned matter to defendant David Michael Tefchendorf at his last known address. The tracking history shows that the items are processed through the Jacksonville, Florida Distribution Center, subsequent Oak Creek, Wisconsin Distribution Center on October 26th at 9/11, and 12:37 a.m. on October 27th, an affidavit of publication from Joe Iovino, the authorized designee of the Daily Reporter, a daily newspaper of general circulation in Milwaukee County, state of Wisconsin, being filed concurrently with this declaration, showing publication once each day following dates, October 27th, November 3rd, and November 10th. I declare under penalty of perjury. Just a little minor perjury. Randy Shockett, 22nd day of January. Okay, and then here is the Daily Reporter. If y'all haven't seen this, I was going to print this out and put it right here. This is the acknowledgement of service from the Daily Reporter. And the Daily Reporter is not a major newspaper, but it is in Wisconsin or in Milwaukee. If you go to the Daily Reporter's website, it is where everybody is served. They are not ever served in the Milwaukee Journal Sentinel that I could find. However, if you go to the Daily Reporter, it is that is all that is there. It is basically a magazine or a publication for publication of service. And that's the thing. Even though people make content and people are making content and whatever, this is still a federal court. It is not something that I would just be laughing at, especially if I had a law degree. There's just certain things that you take seriously, even though you might not agree with them. You can't fight your battles in the court of public opinion when you've been sued. You just can't. It just doesn't, And hey, Barbara, pain meds are not working. Why take them? Fight the side effects. If y'all ever want to do a stream, I think I'm going to do a stream on the other channel. I'm going to start up the Pain Chronicles, series again. I'm going to talk about what I do for pain management, because I have a couple of things that I use for pain management that are non-pharmacological. So, they can basically change their name to You've Been Sued Wisconsin Edition, pretty much. Because I wake up every day and you wonder, you wake up in the morning and you're like, am I going to be able to move today? Am I going to sit up and my head's going to like explode? So I I will. I will. Um oh, and Barbara, I was going to talk to you when you when I defended you the other day and somebody posted about me, please do not worry about it. Um because that person ain't shit. That person, if I don't care about people who can actually hurt me, I really don't care about that person. Oh, maybe not. Maybe not. Coming through with the 20 gifted Squid Pro Quo memberships. You are awesome. You are amazing. And Barbara, thanks Jesus. My attitude, and I tell this to my mother because she goes through it at work too. I'm like, I don't ever put myself in a situation where someone else is going to dull my shine. Um, I don't ever leave a chat because someone in there might not like me or someone else. I don't ever not talk about a subject because it might hurt somebody's feelings. There are people who wake up on a daily basis and are pissed that I stream on YouTube. They are pissed that I make videos. They are pissed that I did a continuing ed class today. They are pissed that I have a smile on my face. So guess what? Knowing that I make them miserable, I keep smiling more. Because who am I to not enjoy making someone else miserable that has tried to be an asshole for 2 years? You know? Beast. I'm having surgery in 1 week, getting an SNS inserted in my spine for my intense back pain. I hope that works. I don't do it on purpose, but I also don't go out of my way to like sugarcoat things because I feel like somebody's going to you know. Yeah, always remember as a vet you've been called worse by better. Yeah, that's true. And working in a hospital, I've been blessed by a nun and called the spawn of Satan in the same day. When I was a student, the first person that I ever worked with at the hospital that I worked at was a mental health patient, but they were there for physical issues. Um, they 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 called me a bunch of things that if I didn't have a strong or thick skin and a good set of I don't give a fuck, would have hurt my feelings and probably would have made me go home crying. Uh, ugh. What's up, baby? What's up, Angel Bug? What happened? What's the matter? Are you okay? Yeah. Do you want to sit on mommy's lap? Oh, do you want mom to plug in your pad? You're fine. You peed. Go sit on the potty. It's a marathon. I will be right back because apparently somebody peed again. She will tell me when she peed. We haven't quite figured out the you know. Oh, now she went back in the living room like it was no problem. I don't know. I don't know. I don't know. So this is the clerk's default. Upon application of the plaintiff in the above styled case and having examined the records, there appearing to be no responsive pleadings filed by defendant. Default is hereby entered against Richard Luthman Jr. on January 22nd. Here's the thing. Yes, it's a win. Technically speaking, it's a win. We're not taking that away from Jeremy by any means. However, that sounds like a personal problem. There is a rule in the Federal Rules of Civil Procedure that Lynette and John have already used in this case. It is 55E. I think it's 55E. I have to look. look up. Do. Boo. 55C. So we're going to look up federal rules of civil procedure 55C. I love my shirt too. I miss Jeff so much. This is one of my favorite shirts. Plus, it's the most comfortable too. All right. Default judgment. So we are going to go to our favorite website. Cornell Law School has a Legal Information Institute. It's like law school for it's like law school. I gotta stop sharing that for a second. Share screen. There we go. Law school for non-lawyers. You just saw the shirt. Where have you been, Gail? I'm disappointed. 55C, setting aside a default or default judgment, the court may set aside an entry of default for good cause, and it may set aside a final default judgment under Rule 60B. So it's possible that it's not over. Do I think that Luthman's going to do that? No, because he's lazy. I just think he's lazy. That's just my personal opinion. I just think he's lazy. One of the reasons that I think he's hopped on YouTube live streams and talked about it, but not actually done anything about it, is because hopping on a YouTube live stream and just venting your opinion about a court case doesn't take a whole lot of effort unless especially when he's not hopping on his own stream, he's doing it on somebody else's, and they've gotten the documents, they've done the work, they've looked up the rules and all of that, and he's just going on there and complaining. Yeah. If Luthman does try to use that rule, he will wait to invoke it until the last moment. I don't think he has that much time. I don't think there's much time. It needs to be done within a week. Let's see. By the clerk, if the plaintiff's claim for a sum or a certain sum can be made by computation, the clerk, on plaintiff's request with an affidavit showing the amount due, must enter judgment for that amount by the court. In all other cases, the party must apply to the court for default judgment. A default judgment may be entered against a minor or incompetent person only if represented by a general guardian. If the party against whom a default judgment is sought has appeared personally or by a representative, that party or its representative must be served with a written notice of the application at least 7 days before the hearing. Court may conduct hearings or make referrals. It doesn't really say in this how long it takes. He's gonna fight it. He'd send some vulgar motion. I don't think that because of the fact that yeah, in his mind, he hasn't been served, therefore the default cannot stand against him. But I don't think he's gonna do anything. I don't think he's gonna do anything. I mean, I could be wrong, but I just don't think he's gonna do anything because the judge already kind of if anything, it'll be his dad who files a motion. You know. So his mommy needs to send the court a note for him. Pretty much. The outrageous thing he's written to judges, officials, whoever he feels like bothering. I don't see it happening. Especially lately, he's been quiet. Like, I don't know for sure. Like, I don't go around to people's live streams and see who's on there. It's none of my business. Don't really give a shit. I'm not like some of these people that hate watch. I just don't see the point in hate watching because, because I just don't have the time. I barely have enough time to watch what I want to watch. However, he did now that football season is over, we have a little bit more time on our hands. A little bit more. And go Indiana. However, with that being said, we are going to ain't got the time to hate watch. I don't see the point in it. I don't know. I don't know. Maybe it's just me. I've always been that kind of a person where if I just don't like somebody, I just won't watch them. Like, I don't, because what I've noticed in just society as a whole is we tend to watch people that we hate, and then you get pissed off because you're watching people that you don't like and you're disagreeing with them and you're getting angry about it. It's like, just turn off the damn TV. So I just choose not to watch people that I don't like for my own mental health. I just, you know, if he comes back with a vulgar motion to set aside, you can bet it will be denied and a final judgment entered. Yeah. I mean, yeah. But just know it's one of those situations where it was like, just because a motion for or an order for default judgment has been entered does not mean that it's 100% over. Let's just make that one extremely, hey peculiar, how are you? It just so we just got to make sure that we keep our expectations. I don't know how to describe that. You keep your expectations tempered, and if something happens, then if all of a sudden a motion gets filed, no one is surprised. Like, you hope for the best, but you plan for the worst. Worst case scenario, he files something, default judgment is set aside, and we're right back at square one. So, he doesn't need to file a motion to set aside right away. He can actually wait till just before the closure of the entire case, since the rule doesn't give him a time limit, only a 7-day notice. Good to know. And thanks, Jeff, for being my spawn shush. Shush. All right, guys. That is all. That is, I've lost track of judges. I know the Pensacola sucks. Which one was he for? Oh, that's between y'all. All right, guys. I have you, Chucky. No, Peculiar's not your nemesis. She's mine. Saying that in good fun. All in good fun. Anyway, Bruce Manskin in the house. I dodge nothing, can't prove it. Just know that's parody account. It's parody account. Manskin. Yeah, parody account. All right, guys. This is all I have for Hales for today. We are going to go over and watch. Well, we're going to go over to my other stream, and we are going to get into the Erica Kirk documents for the Charlie Kirk unaliving case that we've been meaning to talk about for a week. So I hope to see some of you over there to discuss a different case besides this one, because these are getting crazy. Dang it, late. Now you're going to be wanting to cause trouble. Hold on a second, guys. I have a phone call. All right, guys, I am going to send us over to that one. I will hopefully see there's 229 of you still here. Hopefully I will see at least half of you over there. It is an interesting case. It is the Tyler Robinson case. That is the Charlie Kirk alleged assassin. I will take care of you in just a second. And I'm going to take care of my daughter real quick, and I will see you guys in a few minutes. I have no hate for you whatsoever. None. I love everybody. Bye, guys.